Okay, so I'm happy to greet everyone to our Ilan law faculty to this very interesting evening, and I think you will hear later about the contents of the evening. So I'll just say a few words about the commitment of our faculty to the study of global law. I think one of the things that is interesting in our faculty, in contrast maybe to Tel Aviv and Jerusalem, is that we have, I think, a much more pluralistic view of international law, not just public international law or the law of war, both also international economic law, transnational law, which is something I do, international environmental law. This is something, for example, Jerusalem don't know about environmental law. It's very mysterious for them, maybe because they are in the mountains. So it's a very, I think, broad view, and I think it's what makes it interesting. Taxation, yeah, I'll go. Yeah, Arie keeps filling me with additional issues, and so this is, and we are happy that Arie, on top of his other new commitments this year, is organizing very interesting events, and I'm also grateful for the Friedrich Ebert Stiftung. What is it? Support, yeah, for the support, and I hope you will have a very interesting evening.
Thank you.
Thank you very much. So I'll invite the president of the Israel Association for the Study of European Integration, Dr. Maya Sion. The co-president, together with Professor Alfred Tobias, with the second co-president who's also here and honoring us.
So good afternoon, good evening everybody. It's a pleasure to be here again. We have this event at Bar-Ilan University almost every year. I want to tell you for a few minutes just about the association and what are the aims of the Israeli Association for the Study of European Integration. We have been founded in 1992 when the Maastricht Treaty was signed. Professor Tobias was among the founders. The association was established to have, I think, more debate and discussion between universities, but also between government officials and between people who are interested. It could be from the industry, it could be just NGOs or different from the media persons. So we could have a forum for discussion and debate, informed discussion and debate about the European integration per se, and also how the EU, how the European Union influence Israel. So those are the main topics that the association deals with. We have about 80 members at the association. If you would like to support the activities of the association, then I welcome you to join us as members. And I wanted to show you our website through which you have two options. First, you can, of course, see the different activities the association holds. So we just had an event on the anti-Semitism, for example, at the INSS, and different other activities, and I'll tell you a little bit more about them. You can enlist to our email list and get the invitations to all of our events, and you can become members and support our activity. We are completely a volunteer association. We have different members on our board. We have 10 members on the board from different universities. So Professor Arie Reich, who is former president of the association, is of course a member of the board. And we have different other members, such as Dr. Frid-de among us, and many others. So I welcome you to join us. Our future events will be on the 15th of May. We're going to have an event at the Hebrew University, which will deal with fake news and disinformation in and about Europe. And I think it's very timely issue to debate. It will also deal with Israel and Europe in that respect of fake news and disinformation. On the 30th of May, just a few days after the European Parliament elections, we'll hold a seminar on the results of the elections, and also we'll have, of course, elections here in Israel, so we can try and estimate how the European Parliament elections will maybe influence the relations with Israel after we'll know the results of the Israeli elections. So that will be held at Tel Aviv University. On the 13th of June, we'll have another event on social policy of the European Union. So that's the other event, and we have other events coming on. For example, in October, by the end of October, at Kiryat Ono, we'll have an event on Brexit. So this is the future events we'll have. I would like to send my warm thanks again to the Friedrich-Ebert-Stiftung for their support, their long-standing support for the association and those events. This event takes place because, and you, in light of your support, and of course to Professor Arie Reich organizing this wonderful event, and I wish us all a fruitful discussion.
Thank you very much. And I invite Mr. Miki Drill from the Friedrich-Ebert-Stiftung.
Okay. Hi, everybody. Dear Professor Perez, dear Jet Odermatt, our speaker from abroad. First of all, thank you for coming to Israel and attending our meeting here. Dear Arie, Maya, Alfred, Tobias, dear colleagues and friends, we are now in the 7th year of excellent cooperation with the Association for the Study of European Integration. First of all, thank you, Maya and Alfred, for this great partnership between us. The aim of this series is to assist in promoting the understanding of European integration and Europe among academics, governmental officials, and the wider public in Israel. We hope the events in leading universities, like today at Bar-Ilan University, but also at academic colleges and institutions, with the aim to facilitate exchanges to decision makers and experts, thus introducing each other's viewpoints into the public discourse. Together, we choose relevant topics like the one we are discussing today. One of the strategic targets of the FAS work in Israel is strengthening Israeli-European alliances and disseminating information about the EU in Israel and vice versa. This is very important since Israeli-European relations are complex and ambivalent. We try to introduce European viewpoints into the Israeli discourse and Israeli viewpoints into the European one. Now, some words about today's challenging topic. The topic is relevant and fascinating because it actually, in my opinion, deals with the question whether there are double standards of the EU towards Israel in comparison with other countries. Almost every Israeli, including myself, would automatically reply with, of course, this is obvious, just open your eyes. On the other hand, it is difficult to compare when you lack knowledge about other similar cases. In addition, one must always ask himself whether situations are really comparable. I suppose that every case is different. The Western Sahara is not the West Bank, and I suppose that the political regime in Morocco is far away from the vibrant Israeli democracy we are living in. This too should be taken into consideration. Having said this, it is, however, important to compare. So today we will take a closer look at one of the outstanding institutions in Europe, the European Court of Justice, and we'll ask ourselves whether their judgments are not based on the principle of equality before the law, but rather on economic interests, at least when it comes to areas on contested sovereignty. I do hope that the answer to this question is a negative one, because equal treatment and fairness are basic pillars of an European-Israeli alliance, which we as FAS try to advocate here in Israel as well as in the European Union. I wish us a fruitful discussion. Thank you.
Thank you very much. So, I want to, I'd like to introduce our first speaker. You can take the floor here, I think it would be more comfortable. You can help find I should also acknowledge we have several students here. You're welcome to join the table. There's some free places around here. And you're also invited to join the association as members. We have a special student fee in the association. Okay, so Dr. Odermatt is a lecturer at the City Law School in University of London, City University of London. He's originally Australian, right? You have 2 bachelor's degrees from Australia and an LLM from Leiden University in Netherlands, a PhD from University of Leuven in Belgium. Truly international. Then he did a postdoc in Copenhagen at the Center of Excellence for International Courts. And you were also in Cambridge, I believe. And you were a Max Weber Fellow at the European University Institute in Florence. I think we just missed each other because I came there just after you finished. I was a Broadwell Fellow there. And your research interests include public international law, law of international organizations, and EU external relations law. You especially focus on law and practice of international courts, in particular the Court of Justice of the European Union. Please.
Thank you, Arie. And thanks to the organizers for the kind invitation. It's great to be here in Ilan and in Israel as well. Talking about this topic of the EU's engagement with areas of contested sovereignty. And you'll notice that I didn't use the same title that's in the title of the event today, which is Occupied Territories, because, well, one of the reasons is in this research, I'm not only focusing on Western Sahara, looking at other areas of so-called contested sovereignty, and it's used as a more neutral term sometimes, because as you know, the words and the legal terms you use have so much importance politically and legally. So I use in this research the more, I guess, neutral term of contested sovereignty, and don't really go into the issue of occupation or non-self-governing territories and so on. So what I'm going to look at today is mainly the judgments of the Court of Justice dealing with the Western Sahara cases, and to really focus on the way the court used international law in its legal reasoning, but also to touch upon this idea of the political question as well. So to take a step back before we discuss Western Sahara itself, it is important to have a look at what these UN non-self-governing territories are. These are those that are deemed by the United Nations to be those which have not yet achieved full self-determination yet. And there's 17 of these territories. It doesn't mean there are other territories that aren't yet to have achieved self-determination. For instance, there's discussion of West Papua in Indonesia, that may be another entity that is yet to exercise its right to self-determination and achieve sovereignty. 2 of the administering powers are also member states of the European Union. One of them might be leaving soon as well. And interestingly, one of the territories, Gibraltar, is in the territory of the European Union as well, which also gives rise to some interesting questions when it comes to Brexit as well. Not what I'm going to talk about today, however. And I've just listed them here, and you can see the Western Sahara is quite different from a number of the other non-self-governing territories. Most of them have an administering power, which is a Western country, United Kingdom, France, New Zealand, the United States. The other territories are former colonies, mostly quite small island nations, whereas Western Sahara is a very large territory and has a contested status when we look at its status compared to its place in the constitution of other occupying or administrative powers. And of course, it is controlled by a non-Western country, that is in Africa, Morocco. It's also quite large in terms of territory, not in terms of population, but just the landmass alone is equivalent to that of the United Kingdom, and since 1975 has been under the control of Morocco. And Spain is seen by some to still be the administering power. This is a position that Spain itself does not consider itself to be administering the territory of Western Sahara anymore. And it has been, as I mentioned, on this list of UN non-self-governing territories, which are seen as still having the right to exercise self-determination, something which has been reaffirmed by the United Nations General Assembly on numerous occasions. We also have a politically active body from Polisario, the name of one of the cases I'm going to discuss, which has declared its government in exile, is an internationally recognized entity in terms of political talks that are going on in the context of the ceasefire and the UN peace process in Western Sahara. And to talk about the process in terms of international law, it has been subject not just to the Court of Justice judgments, but famously the Western Sahara advisory opinion by the International Court of Justice, where it was requested to examine the historical ties that Morocco and Mauritania had towards that territory, and found that there wasn't sufficient ties to establish the sovereignty of Morocco over that territory, and reaffirmed in that decision, and I refer to this also because the Court of Justice and the Advocate General on occasions have referred to the Western Sahara advisory opinion, but without going into too much detail on that, it reaffirmed this right to self-determination. And just in case you haven't ever seen a map with Western Sahara on it, I have found one. It's difficult to find one that's not somehow on one of the sides showing Western Sahara being part of Morocco or not. And so this is from Google Maps. And you'll notice that rather than having a hard line, there's a little dotted line here to show you the contested nature of Western Sahara. And I'm told that if I were to find that map in Morocco itself, there wouldn't be a line because it's contested in Google in Morocco itself, that it would be upsetting Morocco to have any kind of line between the two. Why is the European Union engaged with Western Sahara? Well, this is in the context of EU-Morocco relations, but Western Sahara is an area which is of interest to European and other Western companies and exporters and traders. Most of the cases that I'm dealing with today will be dealing with agricultural products and fisheries, but there are also important other resources, including oil and phosphates in the territory of Western Sahara. But the agreements, or the economic relationship between the EU and Morocco is established by a Euro-Mediterranean Association Agreement. This is at the heart of the bilateral relations between the two countries. And in the cases I'll be discussing, there is also the 2010 Liberalisation Agreement and the Fisheries Partnership Agreement, mostly to deal with liberalisation of agricultural products and fishing rights. And these agreements, importantly, don't specify in them what the territorial application of those treaties are. They say that they will apply to the territory of the Kingdom of Morocco. And this is one of the issues that's been the heart of these judgments, but also, if we discuss later on, the Brita judgment as well, not having the territorial application in the treaty may be issues. Although it applies to the territory of the Kingdom of Morocco, it has been de facto applied in relation to the territory of Western Sahara, and goods originating from Western Sahara have been treated as coming under this agreement in de facto application. And so at the heart of this research question is this idea of how can the European Union continue to have economic engagement with Morocco, which it seeks to have, while at the same time respecting international law, in particular the right of self-determination of the people of Western Sahara. And this is a commitment that comes under international law, but also is something that is in the EU treaties itself. Okay? So just to have a look at two parts, well, one part of the EU treaties, Article 3.5, which sets out how the European Union is to engage with the rest of the world. This says, and has a whole list of all the different goals that the EU is set to achieve in its relations with the wider world. But at the end, we have strict observance and the development of international law, including the principles of the UN Charter. This may sound like a very vague and lofty goal, but the Court of Justice, and here I have a quote from where this was most clearly stated by the Advocate General, this means that the European Union is to observe international law, including customary international law, and that treaties that are not in accordance with international law could be, as with other EU acts, found to be invalid under Article 3.5. And this is what was the basis of the challenge in the cases I'm discussing. The first was a challenge by the group from Polisario, which sought to annul a decision, not the treaty itself, not the agreement itself, but the decision approving the liberalisation agreement. So this is just the process under EU law by challenging the Council decision itself. And the court in this case had two main issues to look at. The first was basically whether the court could hear the case, whether Front Polisario did have standing under EU law. Right? The other questions were more substantive, and whether or not the Council decision itself could be annulled. And what was the basis for annulment? There were a long list of issues under international law regarding self-determination, but also international humanitarian law, law of occupation, and so on, but also under EU law as well. For instance, saying that there were failure to state adequate reasons by the Commission and the EU. Regarding the first question, the court focused on whether or not the decision was of direct and individual concern to Front Polisario. This is what was required in order to show standing to bring the case. And the court focused on this issue of the territory, whether or not it produced legal effects for Front Polisario. So it didn't focus so much on whether or not the agreement applied with respect to Western Sahara, but the fact that it produced legal effects. It also looked at whether or not it could find a ground under international law to invalidate the Council decision, and found there was no general prohibition in international law to engage in such a way with a, quote, disputed territory. That was the terminology the General Court used. And didn't find a violation stemming from public international law, but rather found the violation that could be used to invalidate the agreement was stemming from EU law. That the EU institutions themselves had failed to give adequate reasons and to ensure that they did not infringe on the fundamental rights of the people concerned. So there was initially an annulment. This was immediately appealed. This was also causing, we think, outside of the court, also causing a lot of diplomatic problems with relations with Morocco, because the court basically said that this is not territory of Morocco, this is a disputed territory, something which has a distinct status from Morocco.
And the people have the right.
And of course, yes, the people have the right to self-determination. This was something that would be politically problematic, perhaps, putting those relations in. But just the idea of saying that there was distinct status under international law of Western Sahara itself was something that would cause problems. And the Council appealed, and in the Advocate General's opinion, Advocate General Watley discussed this idea of disputed territory and said, no, this is not a disputed territory, but something which has separate and distinct status under international law. And looked at this question again of whether or not there was standing. And this turned, in his opinion, on the question of the territorial application of the treaties, not really looking so much at what happened in practice, the de facto application, but the legal application in terms of looking at the treaty itself, and really went through a process of interpreting the treaty in accordance with the Vienna Convention law on treaties, and found that Polisario did not have standing because it was not affected by the agreement itself. And this reasoning was also applied, in the most part, by the court as well, where it found, and continued with the reasoning of Watley, that Polisario's action was inadmissible, again focusing on this issue of territorial application, and went through a process which, on the face of it, seems quite open and friendly to international law, saying we're going to interpret EU law in the light of customary international law, of treaties, and to say, well, we also pay attention to the principle of self-determination, the territorial scope of treaties, and the pacta tertis rule on the relative effect of treaties, which we'll also hear about, I'm sure, when we talk about the Brita judgment as well. And one of the interesting or important parts of this was to what extent and what was the importance of the practice of the parties. Could the practice of the parties themselves in applying de facto the treaties or the agreements to the territory of Western Sahara be something which would change the interpretation of the agreement? And the courts disagreed with this argument, that the de facto application couldn't be seen as subsequent practice in the application of a treaty, and set a very high threshold for this under the law of treaties. And in doing so, the court also used some strange reasoning, I think. When interpreting this and applying this principle of international law, had to look at the intention of the parties to see whether or not there was an intention of the parties to basically change the interpretation of the agreement through practice. And the court said to do so, if the court were to find that this was the case, this would have entailed conceding the European Union intended to implement those agreements in a manner incompatible with the principles of self-determination and the relative effect of treaties. So, interestingly, uses, I mentioned Article 3.5 before, the professed engagement with international law, EU law, international law in friendliness of the EU in order to interpret an agreement between Morocco and the European Union. So I see this as a way of so-called interpreting away the conflict and finding a very difficult, very high threshold on which the court would ever find that an EU agreement could violate international law and can be invalidated. To date, the Court of Justice has never found that an agreement concluded by the European Union could be invalidated, not on the basis of an EU law issue, but on the basis of it not being in accordance with treaty law or customary international law. So the Council won, but we still have, and this was a judgment in December, around Christmas time, a victory, a kind of victory from Polisario, because, as I mentioned, this recognition of the territory of Western Sahara being having a distinct and separate status of international law. So lost the case, but still seems to have won and had a victory in that sense. There was another challenge, not this time coming from Polisario, but rather from an NGO based in the United Kingdom, Western Sahara Campaign. It was a challenge which was different also because it was procedurally different. It came by the so-called indirect route, not a direct challenge, but a challenge through the courts in the United Kingdom, where proceedings were brought before the High Court in England and Wales, which then made a reference to the Court of Justice on interpretation of EU law, and really focused on this idea of whether or not Article 3.5 could be used to challenge the validity of an agreement. This time it was an agreement that applied to the fisheries partnership. So the fact that there was fishing taking place, fishing rights, with respect to sea off the coast of Western Sahara. So now it wasn't just the liberalisation agreement, but also the fisheries partnership agreement, and used very similar argumentation. And one of the parts of the reasoning that came up in the previous judgment was that the agreements themselves were not concluded either for the benefit of the people of Western Sahara or with their consent. And this was something that arose from the, well, I don't want to go into too much detail, but a legal opinion on Western Sahara coming from Hans Korel, saying that such agreements would need to be based on the consent of the people of the territory or on their, for their benefit. I mentioned that it was quite different in terms of the procedure. So one of the questions was whether or not using this procedure, a reference procedure, you could challenge the validity of an international act. And here the difference was, it wasn't challenging a council decision, but the international agreement itself. The court didn't really find this to be that relevant. What was the difference between a council decision approving an international agreement, the international agreement itself? I find this to be important because they exist in different legal worlds. One is on the plane of international law between a third party. One is a decision within the EU. The court didn't really find this to be that legally different. But the court basically continued with the same legal reasoning, focusing on the territorial scope of the treaties. And I think what's interesting here is that there's a difference between what the Advocate General did in this case and the process of the court. The court really focused on what the text of the treaty itself said, used similar reasoning that you found in the Polisario, but the Advocate General said we need to also interpret this by looking at the practice of the parties. What is happening in practice? Okay? Let's look at the broader context of the dispute. It looked at more activity of the UN, but also the activity of the parties in terms of what fishing rights were used and so on. So, am I critical? What do I think of this? What do we get from this? Well, on the one hand, I'm critical of the way the court uses and instrumentalizes public international law in this way. But we can also perhaps see the court subtly strengthening the rule of law. How is that? Well, by ensuring that in the future, the EU institutions take more care to ensure that they take into account international law and the interests of the people of Western Sahara. And so one of the examples of this was the public consultations taking place by the European External Action Service and the Commission when it took public consultations to see whether or not, in concluding an agreement with Morocco, this has a positive impact on the economic rights and human rights of the people in Western Sahara. And if you find this document, it's interestingly not so easy to find on the website of the EU. It finds that most people now living in Western Sahara are very much in favour of the extension of tariff preferences to products from Western Sahara. Maybe I sounded a bit sarcastic when I said that, because it's very difficult to find out. From Polisario themselves boycotted this process, and other non-governmental bodies and civil society did so as well. There's lack of data on goods. Morocco doesn't keep any data on goods originating from Western Sahara because it treats this as part of its territory. Who needs to be consulted? All right? Meeting with a few different local organizations won't show you what the people of Western Sahara actually believe.
People in Western Sahara includes the settlers. The Moroccans brought a few 100,000 settlers from Morocco into Western Sahara.
And the other thing is it's not so open and transparent about the process. There is a list of organizations in an annex about who the Commission met with. There's not really much about what was discussed or anything like this, but they were able to conclude that this was for their benefit. And that is also a question. Is the fact that the Commission itself decides that this is an economic benefit for the people of Western Sahara enough? They also have a very narrow way of looking at this, looking at the economic benefits or not. What about the political process of actually, and this was the argument made by Front Polisario, that this is detrimental in the political process, it's not a neutral action because it continues to recognize the status quo and consolidates what would appear to be Moroccan sovereignty over the territory. Whereas the Commission in one sentence dismissed this argument entirely, saying that it didn't want to engage in a political argument, which I think is too easily dismissed. And so we find as the next steps, the Parliament did give its consent to a Council decision on the conclusion of an agreement between the EU and Morocco. And interestingly, to see how this is sold, the name of the press release is Preferential Tariffs to Help Western Sahara to Develop. So it's presented as a very positive thing, almost as if it's part of the development of Western Sahara. And in order to get this passed, the European Parliament had a non-legislative resolution saying that, well, we need to have a mechanism in place to allow member states' custom authorities to have information about the products originating from Western Sahara. Basically, this is an issue of making sure there's some kind of labeling, right? And whether or not this will actually be done in the member states is another question. I'm not sure if we'll have labeling of products as originating in Western Sahara. And recalls that the Court of Justice did not specify how the consent of the people of Western Sahara is to be expressed. This just means that perhaps, well, almost certainly there will be further litigation, and the tactic that the court has taken so far, which is really trying to avoid a very politically sensitive issue, perhaps won't fly anymore, and the important international law questions the court dodged in those cases will probably, unless other avoidance techniques are used, will come up. And these questions are really important ones. What is the obligation towards such territories of the European Union under international law and EU law? And does this include an obligation, as it was argued in these cases, not to recognise a situation created through a serious breach of preparatory norm of international law? Lastly, there was an argument made by the Council and the Commission in these cases that this shouldn't be dealt with at the court at all because it's a political question. Trying to use something like a political question doctrine that exists in the United States, there's some similar in other common law jurisdictions. The court said, no, we're not going to, we need to have a system of rule of law, we're still going to apply the law to this situation, but still, in essence, apply some kind of avoidance techniques to make sure that it doesn't answer what I think are the most important international law questions, the substantive questions the court will have to at some stage address. Thank you for your attention. I look forward to continuing this debate discussion with you.
Thank you very much. Okay, now I invite my colleague, Professor Guy Harpaz. Rachel first, sorry. Dr. Rachel Frid-de is the lecturer at ONO Academic College, previously the Carmel Academic Center. She has lectured here in Ilan University, teaching European Union law, and in Int'l University, and international trade law and EU law. And she worked for many years in the Department for International Agreements in Israel's Ministry of Justice. She got an LLB from Tel Aviv University and LLM PhD from the University of Amsterdam. And Rachel's research interests are in EU law, international law, and she has written extensively about the EU as an international actor.
Thanks for joining us. And I'm so happy, as I expected, Jed laid the perfect basis for my discussion, so I will not have to go through all the details and just jump straight into the water. And I'll try to be a bit more, maybe I'll allow myself what I don't allow myself so much in articles where I'm trying to be more neutral or careful and academic. So you will see that I allow myself here to say some blunt things, and I hope it will create an interesting discussion. So just to, you heard from Jed about the first, maybe just to stress, the first case in the EU was by the General Court, which is the kind of lower instance, and then it was appealed to the Court of Justice EU. And I want to compare a little bit between those two. Both courts dealt indeed with the question of standing, or the common point for both courts was the question of from Polisario, do they have a standing before the Court of Justice of the European Union? And in order to have standing, one has to be of direct and individual concern. This is from the EU treaty. Both courts agreed that this question is an interpretive question, and that the main thing would be to, in order to decide whether the Front Polisario was directly concerned in this case against the EU, is that whether the agreements, both the association agreement, liberalization agreement, all the agreements with Morocco dealt with, whether they are being applied to Western Sahara. And as Jed said, the agreements are kind of silent or vague about it, because the agreements talk about the territory of the Kingdom of Morocco, an interpretative question. And oddly enough, both EU courts reached opposite conclusions on this interpretative question. The GC, the General Court judgment in general, in short, said about the admissibility that it was in fact a situation of, from the side of the EU, of application of the agreements to Western Sahara without recognition, without political recognition of the Moroccan sovereignty over Western Sahara. The court emphasized that the EU institutions were aware of and partly participated in the application of the agreements, and therefore, I make it very short now, the Front Polisario was directly concerned, and therefore the application was admissible. Then the General Court went into the merits of the case, and as was explained, decided that the Council of the EU failed to fulfill its duty with regard to human rights in the Western Sahara, and the result was from the GC, from the General Court, of partial abolition of the contested regulation. The appeal went to the CJEU, Court of Justice of the European Union. I made it here really sarcastic a bit, if you will allow. You can say that the Court of Justice said that it would be illegal under public international law to apply the agreements to Western Sahara without its consent. After a long discussion, the agreements could not have been applied to Western Sahara because the EU, in fact, respects public international law. Therefore, the Front Polisario had no standing, and the General Court's case was set aside. So, what are the weaknesses, the main weaknesses, because I find many weaknesses in the Court of Justice interpretation. I will not have the time to go into it, but the analysis of the agreement's scope under PIL, public international law principles, is incomplete and it's slender, and in some cases it's wrong. The court applied those principles without due regard to the parties' relevant practices, and this is, to my opinion, unpersuasive. The court did relate a lot to the Vienna Convention on the Law of Treaties, and among others, the rule that any subsequent practice of the parties is very important for the interpretation of the treaty. The General Court, the lower court, had rightly, to my idea, given much weight to the parties' practices, while the higher court, the ECJ, referred to them as incidental, despite very clear statements to the contrary by the EU institutions themselves, and the fact that the ECJ was in fact dealing in appeal, so not looking closely to the facts. the instance that was looking to the facts was the general court, the lower instance. Nevertheless, we should also remember that the practice of the parties, Morocco and the EU, is a very long practice. We are talking about, I think the association agreement went into force in 2000, was concluded in 1096, and was in force in 2000. The contested agreement in this case was concluded in 2012, so we're talking at least about 12 years of applying the older agreement and then the newer one. And one has to remember that under international law, also such a length of time of practice creates legitimate expectations of all parties concerned. I continue with the weaknesses, and I'll make it a bit short. One of the major points of critique is that by concentrating, by the fact that the European Court concentrates on this so-called procedural point of admissibility of the claim of Polisario, and at the same time overlooking the EU's practice in Western Sahara, is regrettable, because the court avoided deciding some very substantive claims of the Polisario, which relate to EU's alleged violation of public international law and of EU law. The implications, possible implications, many, but I'll just try to give a few. As a result of this case, which the ECJ declared inadmissible, no standing, the Polisario in fact cannot challenge the de facto application of those agreements to the Western Sahara territory. For Morocco, the decision of the European Court, in fact, unilaterally changed a scope of application of the treaties that was applied, as we said, for many years. What about the effect for future agreements? And naturally, there becomes also, it creates an uncertainty for other EU partners, trade partners, as the EU is a very, very important trade bloc. Both for the Polisario and Morocco, indirectly, to my opinion, the European Court made clearly made a position about the sovereignty issues in Western Sahara, that Morocco is not the sovereign. All kinds of questions comes to mind. What are the practical results of this decision? One can imagine that because the European Court decided that the agreements were not applied to Western Sahara, could not have been applied, that the Commission and the Council can continue business as usual. And on the other side, it can be that the effect of this decision would be that products from now on, from the decision, products coming from Western Sahara and labeled as Moroccan products will not enjoy the trade benefits in the EU market. Is it now negative for the Western Sahara people or not? There is also from the ECJ's decision no clear obligation, none whatsoever, at least not directly, to the Council of Ministers, unlike the judgment of the General Court. And as I said, there was no decision on any breach, any alleged breach by the EU itself in all these years of public international law regarding Western Sahara. So this raises some uneasy feelings about political aspects of the case. Judge just hinted to it, and I, as promised, go in. And I say, although the Polisario action was inadmissible, the ruling of the European Court touched indirectly on the merits of the dispute over Western Sahara by excluding this territory from Morocco under the agreements. One has to stress that the battle, this legal battle, was adjudicated by the EU, which is one of the parties to the agreements, even though it involved essential economic, and I underline, political interests of a sovereign third state, Morocco, which is a party to the agreements, but not a party to the litigation. the litigation was not over mere technical details, but over a vital component of the agreement, the scope of the agreement. Some argue that this decision is confined to the EU internal legal order and does not oblige Morocco. This is problematic because in any way we look at it, it will substantially affect third parties like Morocco or other non-EU countries. So my biggest concern at this point is, and I cite other people talking about the judicialization of politics, or, in this case I'm afraid, politicization of the judiciary. Recommended path to my idea would be to use, instead of a political approach to international law, rather a trade approach. The European Court itself stressed that one should use, according to the Vienna Convention, any relevant rules of international law. One should wonder, why didn't they apply trade rules? Because predominantly these agreements deal with trade. So, just a few suggestions of under trade law, the GATT. The GATT would be an excellent example for inspiration for the European Court. The GATT would look to such territorial disputes dealing with trade with a very pragmatic approach. Who is controlling or administering this customs territory? And the reliable customs authority, according to the EU institutions, is only Morocco. And the important thing to stress is, if you take this approach, this trade approach, you don't give the political recognition to the parties. You just stress that the only customs authority available or reliable is the Moroccan one. But you can keep on politically not recognizing Moroccan sovereignty over this disputed territory. Under GATT Article 26.5a, it's even more to this point, and it declares that GATT members, such as Morocco, can have, what is it here? Each government accepting this agreement does so in respect, can accept trade agreements in respect of other territories for which they have international responsibility. And international responsibility was clearly defined somewhere else in the GATT discussions as trade agreements on behalf of territories under their military occupation. Another suggestion from trade law is the effective interpretation principle. We have to keep in mind that the political process regarding Morocco and Western Sahara has not been completed. It's under negotiation. And the parties, also the EU, has long-standing practices in Western Sahara. The EU has explicitly included Western Sahara also in other agreements with Morocco, fisheries agreement, aviation agreement. As Guy will show us, also the European Court case law is also not consistent. Other states outside the EU, I don't have time to go into the details, like the United States and other states and European states, have different state practice regarding the Western Sahara. So there is no one attitude in state practice. So therefore, I would suggest to apply the rule of special meaning, again from the Vienna Convention, and in this way one can interpret the territory of the Kingdom of Morocco as including Western Sahara for trade purposes, allowing the use of trade as an instrument of foreign policy to support Western Sahara. Application without recognition. Recent developments were mentioned luckily by Jed, so I can jump to my final conclusions. Am I on time?
Yeah.
Wonderful. So, we couldn't go into the details, but the interpretation of by the European Court of vital component of the agreements under public international law, the interpretation is unpersuasive. And not to forget that the court that has done the interpretation is the court of one of the parties. It's a very influential court. And in the absence of the other important party, Morocco. The ruling on the scope of the agreements is difficult to grasp because it's ignoring the practice of the EU and possible EU liability. The incidental ruling by the ECJ on the Western Sahara and Morocco political status through procedural process of admissibility is also very questionable. Trade agreements, or the important thing about trade agreements to stress is that they require stability of trade, long practice, legitimate expectations, no unilateral change by a court of one of the parties to the scope of the agreements after so many years. I end by saying that naturally, I guess for many people, including myself, and probably the European Court, those decisions or those implications are more the desirable rather than the practical. It has been suggested that in fact the ECJ very simply wanted to narrow down the admissibility of political claims by non-state actors like the Front Polisario rushing to the EU to get a decision regarding their political riots at home. However, if this was indeed the legal policy of the ECJ, it is not very successful. As we heard, such claims can come from the preliminary ruling path. It has also been suggested that very nobly the ECJ, as a court of justice, might want to align EU trade practices with EU values and public international law principles. However, you cannot force it without looking to possible violations by the EU itself, as much as you want to say that the EU is the champion of public international law. And it has also been suggested, and I say it very carefully, that the European Court of Justice, one of its characteristics is that it wants to become an influential court beyond the European Union sphere. But having all those desires, it's very problematic. The problematic interpretation of public international principles, detached from the EU practice, touching upon sensitive political questions, might be, to my mind, more harmful to the reputation of the court and to its legitimacy, to its position within the EU system, and possibly to the international rule of law, because of its magnitude. It's a very important court. As I mentioned, the preferred path, to my mind, would be a trade law approach, acknowledging the practice of the parties, including the EU, to include Western Sahara in the agreements, irrespective of political recognition. Therefore, I think the claim should have been admissible. If it was admissible, the European Court of Justice could have demanded the EU to meet its duties towards Western Sahara under public international law, just like the General Court did in a way, but not depriving the Western Sahara of the benefits of the agreements, or even advancing a separate agreement between the EU and Western Sahara, like, for instance, the EU and the PLO. And last but not least, as was mentioned, it is in the EU treaties, and it's very important for the EU to support all efforts done by the United Nations, and the political process in Western Sahara and Morocco is being handled for years by the United Nations. And in October 31st last year, 2018, the Security Council decided to extend the mandate of the United Nations mission for the referendum in Western Sahara until April 2019. In this decision, by the way, if I may, one little comment, one would find some compliments by the UN to the Moroccan efforts in this process, to the initiative by Morocco for autonomy to Western Sahara, and also some warnings to the Front Polisario to self-restraint with violence on all those ceasefire agreements and so on. Most of what I have said is to be found in this publication, and thank you very much for your attention.
Thank you very much. I now invite Mr. Harpaz. The situation here in our backyard in the West Bank and the Brita case has very much been in the background of the discussions, and now we will move a little bit to the front, I hope. We will hear about a comparison between the situation here and the situation with the Western Sahara and the relation given by the EU institution. Professor Harpaz is a professor at the law faculty and at the Department of International Relations in Hebrew University in Jerusalem. He holds there the Arnold Brecht Chair in European Law. He is a former president of our association, and he writes extensively about EU law. And he is also the Dean of Students in Hebrew U, so we're colleagues again.
Thank you very much. I wanted to speak about international law, international trade, the double standards of discrimination, and the roadmap would be as follows. First of all, I would deal with or describe the two cases, Israel vis-à-vis the OPT and Morocco vis-à-vis Western Sahara. I would argue that the two cases bear some similar features, but despite those features, the EU pursues, as it was mentioned earlier, two very different approaches vis-à-vis Morocco and Western Sahara. It applies the policy of no recognition, but yes for application. But with respect to Israel and the OPT, it applies the approach of no recognition and hence no application. I would analyze some of the implications of this different or discriminatory approach, and I would deal briefly with the two cases from Polisario and the Western Sahara campaign, and I would argue that those two cases significantly reduce the gap between the approach of the EU towards Israel and the approach towards Morocco, aligning Brita with those cases, but I would still argue that the gap was not utterly eliminated but only narrowed. I would deal with some of the implications of the existing discriminatory practices, and I would end with some normative conclusions. So with respect to the comparable features, and again, I'm not arguing that we are in the business of comparing oranges and oranges, but generally speaking, and excuse me for the oversimplified account, the two cases are rather similar in the sense that during the same time, both parties, Morocco and Israel, used the military in order to invade and then to occupy. Both parties use settlements and settlers. Both parties use a certain instrument of walls or barriers. Both Morocco and Israel have very strong territorial claims over those two contested territories. In both cases, the general international community doesn't recognize the territorial claims. In both cases, there are some condemnations, both by the United Nations and the EU. Obviously, the condemnations with respect to Israel are much sharper, but there are condemnations in both cases. In both cases, as was mentioned earlier by Jed, there are critical advisory opinions by the ECJ with respect to Sahara in '75, with respect to the OPT in 2004. And in both cases, the EU concluded at the same time and under the same framework association agreements. In both cases, the EU used a territorial clause which is very equivocal, not stating exactly the precise territorial application. So we are in the business of constructive ambiguity. So basically, the starting point is that the two cases are rather similar. Having said that, with respect to Morocco, for many years, as Rachel recommends, and I utterly reject, as I would try to persuade you, the EU adopted the trade approach, saying Morocco is has effective control, hence it is the responsible entity, hence we would apply the agreements and allow Moroccan corporations to benefit from the association agreement, whereas with respect to Israel, a very different approach was adopted, namely the international and the sovereign approach, arguing that Israel is not doesn't have any legal title over the OPT, and therefore we would not recognize it. With no recognition, there would be no application, and therefore we would not allow Israeli producers to enjoy from the association agreements. So we see here similar cases, but a very different approach, or traditional approach by the EU. I would argue that this discriminatory, or original discriminatory approach has many implications. I would deal only with two. The first deals with issues of legitimacy. The EU purports to be a normative power over opinion, etc., relying on international law. And in order to serve as a normative power, I would argue that you need a certain measure of legitimacy. You need to act in a legitimate way, and you have to be perceived to act in such a way. And when the EU acts such as it does in this case, in a inconsistent, incoherent, and politically motivated manner, it plays into the hands of many Israelis who would say that as of the 70s we are in the business of double standards and discrimination, and we are not in the business of norms and international law, but we're in the business of business and politics. And as Jed mentioned, the EU undertook under the Lisbon Treaty to strictly observe international law, to uphold and promote international law in all of its international activities, etc., etc. And you see here that it doesn't comply with its promises. So that's one negative implication in terms of legitimacy. The second implication might be an implication of international law, issues of MFN, discrimination under international trade law. Our Ministry of Justice argued that this case may raise issues of MFN, and Israel may consider bringing proceedings against the EU in WTO, in the WTO, but I wouldn't get into this detail. I think that I have a different approach. In any event, we see here a very different approach, a huge gap, and I would argue that the gap was significantly reduced by the two judgments. The first, from Polisario, where, as was mentioned earlier, the Court of Justice denies the extraterritorial application of the agreement based on self-determination, arguing that to apply the agreement would mean that the EU purported to act in a breach of its obligation towards the principle of self-determination. A second argument was with respect to Article 29 of the Vienna Convention, which states that the treaties are binding upon each party in respect to its entire territory, and the court says that as a general rule, its territory means that it applies to the territory recognized under international law and not beyond that. And if a state wishes to deviate from this general rule, it should use recognized formulas such as under the jurisdiction as opposed to territory. This formula was not used, and therefore there's no application. A third ground for the judgment by the Court of Justice relied on the principle of a relative effect under Article 34 of the Vienna Convention, and the fourth ground was good faith. So the first judgment by the Court of Justice denied the extraterritorial application of the association agreement and the liberalization agreement, etc., etc. And then came the Western Sahara campaign, which is rather different. It was not mentioned earlier, but the fisheries agreement actually purports to apply to the territory of Morocco and to the waters under Moroccan's jurisdiction. And this term was used 3 times in the relevant agreements. When the Advocate General read the agreement, he came to the conclusion that it actually applies to extraterritorially, but the court says it doesn't apply because the extraterritorial application would place the EU under dual breach. The first is breach of self-determination, the second is the breach of relative effect of treaty. So all in all, the two judgments, I would argue, align the judicial approach of the EU with the Brita case, in the sense that in those two cases the court refuses to recognize extraterritorial application. And at face value, I think that those two judgments, as was mentioned earlier, at face value they are impressive. First of all, there's at least at face value heavy reliance on international law, which is impressive. It's different than Qadi. In Qadi there was almost a neglect of the legitimacy of international law, with would ascribe a lot of force, a lot of weight to EU law, and here you see a much more modest court willing to place much more emphasis on the international law. We see this consistency, which is very impressive, because we Israelis can no longer argue about discrimination in the court, in the sense, as Mickey mentioned, in the sense that the same court uses similar reasoning to reach a very similar conclusion with respect to those two comparable cases. And I would argue that this, and I do not have time to elaborate, but I would argue that one of the impressive outcomes of this judgment is that it puts international trade law in harmony with international law, and I would actually advocate for an international agreement as international approach as opposed to trade approach, but I do not have the time to defend my approach. I would only provoke you to think about a situation of this evening, the Hezbollah conquering the Galilee, and Lebanon invoking the Lebanese EU association agreement with respect to the Galilee. I suspect that neither Rachel nor me nor any other person in the room would be very happy or support such an application, and I think that international law shouldn't be in the business of providing benefits to the one who commits very grave breaches of the most central and sacred principles of international law. So I have a very different approach. So at least at face value, the judgments are very, very impressive, although they have many difficulties. Both of you mentioned them. I would say that the second judgment is even more problematic, because the second judgment is based on a territorial clause which states that it applies to waters under the jurisdiction of Morocco. And in the first judgment, the court used the same formula as an indication for the fact that such a formula can indicate extraterritorial application, and the same court actually commits a U-turn and refuses to recognize the use of this formula as conveying the message of extraterritorial application. And if I may join your cynicism, the court says, well, they wrote under the jurisdiction, they acted in such a way for so many years, but we cannot accept such a construction because it cannot be assumed that the EU meant to breach these principles. But courts are in the business of scrutinizing the executive, and if the court comes to an almost axiomatic assumption that the executive is not in the business of breaching international law, so why do we need it? I mean, it's very strange to assume such an assumption, generally speaking, and especially in face of such a consistent practice of breaching international law by the EU. So I would argue that the judgments are impressive in some ways and unimpressive in other ways. But the bottom line when it comes to discrimination is that at face value, the two cases, the Brita and Western Sahara, are aligned. Having said that, I insist, as an Israeli, I mean, we would never forgive the card of being the victim and discrimination, etc. So I insist that there are some major remaining manifestations of discrimination. The first is obviously the fact that the EU would require from Israel a certificate of origin. The same request, to the best of my knowledge, is not required of Morocco. The second is the insistence by the EU vis-à-vis Israel that each and every trade agreement, such as the Horizon Agreement or any other agreement, would include in an unequivocal terms a clause that would exclude the territories. The same requirement is not applied vis-à-vis Morocco. The third difference, the practical difference, is the guidelines which state that the EU would not provide financial assistance to activities in the territories or to entities situated in the territories. The same is not applied with respect to Moroccans pursuing commercial activities in Western Sahara. And the fourth de facto discriminatory practice is the labeling requirements. You add to that the fact that de jure discrimination, the EU would treat the OPT as occupied, but with respect to Western Sahara, it uses a much more cautious language, contested, etc., disputed. And you add to that the fact that the EU had the courage of, I would praise it, but it had the courage of concluding a trade agreement with the PLO. It didn't have such a courage to purport or to try to conclude a trade agreement with some local entities in Western Sahara. So I would argue that that there are still major differences, and if I can zoom out, at the end of the day, the bottom line is that the EU invests a lot of energies in trying to sharpen the green line and making sure that no Israeli would profit from commercial activities in the West Bank. This is the differentiation agreement, a very bold, very solid, very consistent policy. So the EU does everything in its powers to prevent Israelis from profiting from Israel's presence in the OPT, but in a sharp contrast, and as Jed proved in a very elegant way, the EU would do everything in its power to make sure that Moroccans would actually enjoy from the occupation by the Kingdom of Morocco of Western Sahara. And those explanations are, I think, embarrassing. I mean, saying that the majority of inhabitants see that as an economic benefit. I mean, the procedure, I think, is defective, and the bottom line is defective. I have a second passport. It's a South African passport, and I'm not making any comparison whatsoever with any one of those cases. But for many years, the apartheid regime said that apartheid is great for the majority of blacks in South Africa because South Africa was a very developed country, which is not in this case. But when you pursue this argument, you can actually say that the Palestinians should thank Israel for the settlement campaign because it provides occupation in building the cities and villages in the West Bank. So I think it's an appalling argument, and this fetishism or insistence by the EU of not respecting international law and not respecting the spirit of the judgments and doing everything in its power to apply the agreement, I think is worrying. At the end of the day, and just to remove any doubt, I'm not arguing that the common commercial policy should apply to occupied territories. I'm not saying that. I'm not saying that the EU should not intervene in political issues. I'm not saying that judicial bodies shouldn't intervene in disputed or contested or sensitive issues. I'm not saying that the EU should not exert pressure on Morocco and Israel. I'm arguing the exact opposite argument. I argue that the CCP and any activity of the EU should be subjected to international law, as the Lisbon Treaty states in the most clear words. I would argue that the CCP, the commercial instruments of the EU, should be used in order to promote politics, and should be used in order to promote the values of international law, as any other country in the world does. I mean, Israel also uses its trade agreements in order to promote politics, like vis-a-vis the Palestinian Authority from time to time. All I argue, and it's a very modest argument, is that when the EU uses commercial instruments in such a way, and when the EU relies on international law, it should do so in a very consistent manner. Otherwise, the legal and moral foundations of its activities would be undermined. This is my basic and simple argument. So thank you very much for your attention.
Thank you very much.
And I hope that I didn't convey a too narrow perspective of international law coming from Jerusalem. No, he would.
Okay, so I will give a few comments, and then we'll open it up to questions from the floor. I want to widen a bit the perspective. I will make 2 points. One point is that we have this issue of double standard. And I agree to some extent with Guy that the double standard is more apparent in the behavior of the executive institutions of the EU, the way the Council and Commission are behaving, and less so in the rulings of the court. Although you can't ignore the fact that you said that we have similar outcomes in the Brita case and in the Western Sahara cases. Not really, because the outcome of the Brita case is that products from the West Bank cannot enter the EU without certificate of origin, and we know that they can't get such a certificate of origin, so de facto they cannot enter, as opposed to the products from Western Sahara are continuing to flow into the EU, now with the hecture of the ECJ, so the outcomes are not similar, they're exactly juxtaposed. So one point is the double standard, and I want to elaborate on that. And I also want to bring in here something that we haven't mentioned, another disputed area, which is the northern Cyprus. And there too, the double standard of the EU is very, very apparent, even more so. The other point I want to make is a legal point, and that is that this is not just a matter of cynicism and of double standard on part of the EU, but it has a legal implication, because we know that in public international law, state practice is what creates customary international law. So if we show that, as a matter of fact, countries are not behaving in a certain way, in other words, they do not, and the point here is that there are some international legal authorities, for instance, Professor James Crawford, who are making the claim that any involvement in a disputed occupied territory, investment, trading, etc., is illegal per se under customary international law. And
No, it's not a conventional approach.
okay, exactly. So that's exactly the point. Also, the General Court made that point that it's not the law and the Advocate General, and also the fact that we show that this is not the way that states in fact are acting, that has very important legal implication to reject that position. So you mentioned most of the things about the Western Sahara, but for instance, another important point. It was mentioned here, there was a legal opinion that was given to the United Nations Security Council by its legal advisor, Hans Corell. And there one of his points was that it was illegal under international law to extract natural resources from from occupied territory. You could explore for them, you can't extract them, because then you're basically taking away the richness that belongs to this country, and you're taking it away from them. That's basically called colonialism. But that is exactly what the EU is doing, because the agreement, there is mineral and oil exploration in Western Sahara. Western Sahara happens to be very rich in minerals and natural resources, and the fishing. And the main point was not whether they agreed to the tariffs or not the tariffs. The point is whether the people of Sahara is getting enjoyment of those natural resources that are in their territory. They have a right to. And this is something that wasn't, as far as I understand, you may correct me, this is something that the EU Commission has not asked in its research or questionnaire. And by the way, the European Union is paying Morocco 40 million euro every year for the right to fish in Western Sahara. So in terms of the state practice, it's very clear what it's doing. And there's no policy like we see in the West Bank of the EU to making sure that no funds will reach Western Sahara. On the contrary, there's many official financial programs that are there to help financially Western Sahara and help Morocco, including in relation to the area of Western Sahara. And by the way, the United States also explicitly, since 2014, authorizes foreign aid to Morocco to be spent in Western Sahara. Also, the product labeling we mentioned already. The EU insists that the issue of product labeling falls outside its association and other agreements, that these agreements don't provide any basis for differentiating Moroccan imports on a territorial basis. But we know that in relation to the West Bank, there is an official policy, at least to allow member states to label products, and where the claim is that this is a consumer policy to prevent deception of consumers. The same policy of preventing deception should be applied to Western Sahara. And if in some of the Commission's statements they seem to claim that Western Sahara is not an occupied territory and therefore there's not an issue of deception, and they seem to be saying that because it was never occupied from any other country. It didn't belong to any other country. This used to be a colony, and the colonial power left. If that is the claim, then this is exactly the position of Israel. Israel's position is that the West Bank isn't, and Gaza was not occupied territory because it was occupied from Jordan, whose possession of the West Bank was never recognized by any country. So there was never an occupation in that sense. So
the ECJ explicitly dismissed this line of argument.
In the advisory opinion, right, not in the judgment, in the advisory opinion, which Israel was not part of. But the EU seems to be holding that exactly opposite position. Now coming to Northern Cyprus. So just to remind you, in 1983, Turkey purported to declare the independence of a Turkish Republic of Northern Cyprus in those areas of Cyprus that Turkey controls. There's no country beside Turkey that recognizes this Republic of Northern Cyprus. But nevertheless, the EU nor its member states have never suggested that European companies could not engage in commercial activities with Turkish firms involved in the occupation of Northern Cyprus. And it's mainly Turkish companies who are doing all the business over there. The whole economy is dominated by Turkish firms, and its trade is conducted mostly with Turkey and a few other Islamic countries, such as Lebanon. And in some, for instance, there is a big project called the TRNC, Potable Water Supply Project, which is done by a Turkish Ministry of Forest and Water Affairs. And this same project involves also European companies and American companies. They don't seem to have a problem with that. And also in terms of universities, something that is of interest for us. We all know that in Horizon 2020, it was a big fight about the fact that they had to be very clear that no money would go to any universities situated or doing any research or any activity over the Green Line. The fact is that there are many universities that have been established in northern Cyprus by Turkey, which attract both Turkish settlers and many foreign students. In recent years, enrollment has surged to 64,000, and this has become one of the most significant economic sectors in the territory. And some of these universities, they have exchange or other cooperative programs with major British public institutions. This has not, many of those institutions are actually branches of mainland Turkish institutions, but this has not led to the exclusion of these Turkish universities from any international academic program, nor to any demand that foreign aid to such universities be certified not to reach northern Cyprus. These universities themselves were accepted as members by many educational organizations, such as European Association of Universities, the International Association of Universities. Just after Israel concluded the agreement, Horizon 2020, with the EU, a similar agreement was concluded with Turkey. We can find no such provision in this agreement restricting funding to programs that are taking place in northern Cyprus.
It was also challenged, I thought, the Anastasia was not in case for the ECJ.
That has to do with products.
Yeah.
So again, this is the ECJ ruling, which is in line with the Brita case and other cases, which basically says that you cannot, those products from Northern Cyprus cannot enjoy a certificate of origin of Cyprus. So in that sense,
of the Republic, the Turkish Republic.
yeah. But in every other activity having to do with, as I mentioned, there I see more of a problem. So as I said, two things come out of it. It comes out that there's a double standard and there's the realpolitik that often gets the better part of the governments than, has more influence than international law. And it also means that there is no real state practice, like it's often represented, that to do any business in the West Bank is against international law, etc. And by the way, there's something that many people don't know, and I will finish with that. People know about the fact that products from the West Bank cannot enjoy duty-free treatment when they enter into the EU, for the reason that they cannot get a rule of origin certificate. But there is okay, but they can still export the products and to pay the tariffs. There's a much more serious problem with agricultural and food products, because in order to be permitted to be imported into the EU, they have to present a sanitary or phytosanitary certificate. And the EU has proclaimed that it will not recognize any such certificates, even though they are issued by the same Israel Ministry of Agriculture that issues the certificate for agricultural products from within the Green Line. But once they cross the Green Line, all of a sudden they lose their expertise somehow, and they're not able to sign any of those certificates anymore. So de facto it means that there can be no agricultural export, at least not officially, from the West Bank, from the Jordan Valley to the European Union.